There are many important things that lawyers should keep in mind when they're writing briefs to appellate courts. Let me give you 5 tips that you may find useful. First, know your audience. When you're writing an appellate brief, you're writing to an appellate judge who does pretty much nothing but read all day long. It's not uncommon for an appellate judge to read literally hundreds of pages of briefs per day. So as a practitioner, your job is to get to the point as quickly and concisely as you can and write a brief with clarity that succinctly explains to the judge why your client deserves to win. Second, avoid typos and grammatical errors in your briefs. We're all human, judges understand that, and every once in a while, even the best lawyer is going to submit a brief with a misspelling or a grammatical error. But sometimes in appellate briefs, we see page after page riddled with grammatical errors, misspellings, typographical errors. And after a while, the judge starts to wonder whether the lawyer is substantively sloppy as well as procedurally sloppy. So never let that happen to you. You cannot control the law in your case. You cannot control the facts of your case, but you can control the quality of the work product you submit to the court. Third, don't make arguments based on sympathy. There are certainly a lot of factually compelling cases in the appellate courts, and there are a lot of sad cases. And if you represent a client who is a sympathetic figure, it's certainly proper in your statement of the facts to explain why, explain what happened in a way that shows that your client is a sympathetic figure. But once you get to the argument, never convey the impression that you're asking the judge to rule for you based on sympathy. Judges are certainly human beings, and they feel appropriate sadness at compelling facts, but judges take a lot of pride in deciding cases based strictly on the law as opposed to sympathy. Fourth, avoid unnecessary dates and facts in your brief. There are some dates, there are some specific facts that are very important to your case, and of course those should be emphasized in your brief. But anytime you include a statement about something that happened in the trial court that's not really directly relevant to the appeal, anytime you clutter up your brief with dates that really don't matter to the issues that you're arguing, all you're doing is wasting the mental energy of the judges and taking up their time unnecessarily. So try really hard with your finished product to eliminate all of those inconsequential facts and dates in your brief. Fifth, when you're talking about a specific statute in your brief, make sure that you're talking about the correct version of the statute. It's not at all uncommon for a legislature to modify, amend, or even repeal a statute. And sometimes lawyers make one of 2 mistakes. Either one, they don't realize that the statute they're talking about has been amended or repealed, or 2, they're aware of it, but they automatically assume without checking that the amendment or repeal applies to their case without looking at the effective date of the amending legislation. So always do those 2 things before you talk about a statute in your brief. Finally, let me give you a bonus tip, and this may be the most important of all. Always know your standard of review. Every minute an appellate judge is reading your brief or listening to your oral argument, they're going to be acutely aware of the standard of review that they are required to exercise. Is it de novo review? Is it abuse of discretion? Is it something in between? Depending on the issue, the appellate court may or may not owe some deference to the findings of the trial court. And whether you're the appellant or the appellee, it's very important that you internalize what that standard of review is, and you argue both in your brief and at oral argument based on that applicable standard of review. If you follow these tips, you will likely have a successful outcome or put yourself in the best chance to have a successful outcome in your appeal.